The Senzo Mayiwa murder trial has been postponed to tomorrow for legal representatives to go into a pre-trial conference as well as sort out some administrative issues with legal aid. We take a look at these developments with legal expert Tyrone Maseko. Thank you very much, Tyrone, for your time this afternoon. So 4 witnesses had been led in the previous trial, and now we're moving from stage 4 to stage 1 of the trial. Though not desirable, is it unusual?
Good afternoon, Judy. Is it unusual? It's unusual in the sense that it's not something that happens on a regular basis. But whenever required, it does happen. So since this is something that is provided for in our law, it's always been part of our law. As I said, it doesn't happen frequently, but now and again you do have, you imagine that you've got a lot of judges and magistrates throughout the country. They're people as well. Now and again they die, they suffer all sorts of incapacity and are unable to report for work for lengthy periods of time. Or sometimes it's just terminal, and so trials have to proceed. It's not that accused suddenly get discharged on that reason, on that basis. So yes, this is something that does happen from time to time.
Okay. The new judge was quite eager to start today, in fact, wanting some of the accused to plead. However, the defense noting that they need a pre-trial conference, and then they're going to also need to sort out some admin issues with legal aid. Let's start with a pre-trial conference. What does that mean, and what do you suspect that those talks will include? Because we also saw Advocate Mshololo standing up to tell the court, well, the judge cannot say that nothing new will be introduced in this case because we do not know what the state will come up with. Yeah, well, that's actually an interesting one, because you would think that given the fact that we were in the middle of proceedings, the trial had already started in this matter, that preliminary issues that we generally discuss in pre-trial matters have already been dispensed with. The issues of witness lists and the like. Really, you'd imagine that nothing should change in that regard, but I guess there's nothing in law that says that they're not entitled to hold one. In fact, I like pre-trial conferences, because what they do is they effectively ensure that there's a smooth running of the trial and that there are no undue delays during the trial. You can imagine if you start setting matters down for trial, and next thing witnesses are not available for whatever reason, and then those dates then have to be set aside again. It's a waste of the court's time and all the parties involved. So to the extent that you can sort all of that out in a pre-trial conference, which does not take long, less than a day, a couple of hours, it's housekeeping really. That's what it is to do. And the judge pointing out that the evidence heard in the previous trial is a nullity. Yes. What's important to remember with trials de novo is, in fact, put plainly, you can disregard everything that has happened up until now. So all the evidence that's been led, the record as it stands, you can discard all of that. Testimony is going to have to be reintroduced. Witnesses are going to reappear. You can still choose to call them or not to call them. To whatever extent and benefit either party will maneuver, given the fact that they sort of have an idea already of what's to come. That's up to them. But plainly put, the trial really starts as if nothing had happened before, unfortunately. For better or worse, you're starting afresh. There's no regard to the record that would have been before Judge Mohammed. In fact, on the point of nullity, then the interpreter says or something to that effect, and that's not verbatim, that quote. But the judge then coming to his rescue saying that, well, indeed, it's like the trial didn't exist because now we're starting all over again. When it comes to the role of interpreters, because it was Advocate Mshololo who stood up to take exception to what the interpreter was saying, how crucial is getting the right kind of people, but also getting the defense to pay attention when there is now interpretation? I have the greatest respect for interpreters, and I sympathize with them a lot, because it is not an easy job to do. We have legal terms that we just throw out now and again, Latin terms, if you like, at times, and we expect in parties and legal counsel in the room and presiding officers will know what they mean. But most of the time, interpreters are not trained. They're not trained lawyers. So these are not things. Yes, over time and working in court, they sort of, develop that experience and they know these terms. But it's not an easy job to do. So I think one has to have some regard and some forgiveness towards the work that they do. Assist them when necessary, because there's nothing in law that says they have to. Let me put this accurately. There's nothing in law. Well, terms are not. What interpretation is a subject is a question of what you say and how I understand it and how I then pass it on to someone else. Someone else can take the very same sentence, paragraph, and then pass the message in slightly different in different words, but the message gets through. And so, there has to be that latitude afforded to them. But the important thing is that the message does get through. It gets interesting when you've got counsel who actually who speak vernacular and can understand the interpretation, and sometimes they disagree with it. It's then incumbent upon the magistrate or the judge to intervene and to ensure that all the parties are happy with the interpretation. But most of the time, it tends to work. Very little ever turns on interpretation, even on appeal. Very little ever turns on a witness did not understand what was said, and so that's what we're going to decide a case on. Very rarely does that happen.
Okay, because I think it was accused number 3, when he was the first two were then asked, do they understand, do they know that this trial is going to start all over, before they were asked to plead. And the third accused actually wanted to speak to his legal representative, and he wanted to then get more information and satisfy himself in terms of these processes and what they mean. Again, the judge having to intervene there.
That's a huge surprise for me, because what happened today would have been expected from the legal practitioner. So they would have known that we knew this beforehand. So there is no surprise. And what that tells me, that the legal representative, for whatever reason, did not get the opportunity, or certainly did not avail themselves of the opportunity to explain this to their client, which is incumbent on you as a legal representative. I mean, it takes time. You got to explain this to them, and it's deeply difficult for them, because we've had so many days. I cannot count how many days we've had in this trial, and now we're starting anew, and in essence, that is just down the drain. And so it's difficult for accused. It's nice for us to sit here and come to witches, but these people are remanded in custody pending the outcome of their trial. So it is somewhat unfair on them, and so it's incumbent on us as legal practitioners to explain this process to our clients, even before the court can have an opportunity to explain it to them and ask them if they understand. It's our duty to ensure that our clients understand this before the trial commences.
If I'm not wrong, Tyrone, the state mentioned that it was on Friday, the 14th of July, that they put in the order for the previous trial to be nullified. So could that maybe not have led to some of the delays between client and the defense?
No, I'm gonna push back on this one. No, because this is a combination of processes in court, but also processes outside of court. And as an officer of the court and someone who should be au fait with developments generally in the legal profession, you know that Judge Mokgoatlheng has been placed on special leave by the president, and so it is a natural consequence that the trial is going to proceed. For reasons that I explained earlier on, is that you don't suddenly get accused or found not guilty, discharged for a reason that the trial judge is now no longer available. So we know, we can reasonably expect that a new presiding officer is going to be appointed. And we know this is a matter of law, that trials do start de novo, judges die. And so I don't think that one should wait until you actually appear in court on the day and then say, well, now I know. I mean, I sound very critical of my colleagues, but I do really have to push back in this regard. I mean, I expected, we knew, and it's been reported widely that the matter is going to start from de novo, I knew. And so the accused really should have been appraised of what's coming.
Because even the new judge pointed out, well, he asked the question when they were presenting that they still need to sort out their admin issues, especially in terms of pay with legal aid. Now that the trial is starting anew, and the judge asking, well, how far is legal aid? And legal aid is 10 minutes from the court, and wanting to make an application that legal aid must come to the court, sort this issue out, so that tomorrow there's nothing that stops the trial from actually getting underway. How should we understand this legal aid issue?
Yeah, it places me in a difficult position, because you also got to remember, Julian, in fairness, that there are many reasons why parties at trial would want a matter to be slightly delayed, need a bit more time, and so without impugning them at all, may not be the reason why they need a bit more time. So, and I say this for this reason, that I don't foresee a situation where if legal aid has already been appointed and they are on the matter, I don't understand. It's not my understanding that ceases to exist during the course of the trial. They are on record as representing the parties, and so they have to continue that mandate until either terminated by the accused or the trial comes to an end. This trial has not come to an end. There hasn't been a verdict. So why would there be a need to reapply for legal aid? We're dealing with the same case, same case number. If they've been on legal aid, why would they be? Unless we're talking about the appointment of new counsel, new legal aid. In any event, if that was the case, any new legal aid attorney would not be ready by tomorrow to start the matter. We need a whole lot more time to prepare and to take instructions. So I'm not quite sure that, I accept that the judge may have no choice but to give the postponement, but I'm not sure that, that these reasons really hold water, to be fair and to be totally honest with you. But it is what it is.
It is what it is. Tyrone Maseko, really good to see you again. Thank you very much for your time this afternoon. Still to come, the